My name is Jim Holbrook, and I'm honored today to interview Bruce S. Jenkins, United States District Court Judge for the District of Utah, as a part of the 10th Circuit's Oral History Project. Good morning, Judge.
Good morning, Jim. Thank you very much for doing this. I appreciate it.
I'd like to start at the very beginning and have you share with us some information about your parents.
Well, my dad and mother both came from Utah County, as a matter of fact. My mother from Salem, my dad from Goshen. He was a school teacher, and my mother was a full-time mom, other than the fact that she was highly skilled as a writer of shorthand, and she was a skilled typist as well. And so on occasion she would make use of those skills.
Now, you were born in 1927?
1927, May 27, 1927, which in one sense seems a long time ago, in another sense seems only yesterday.
Some of our audience may not fully appreciate that the Great American Depression began in 1929, 2 years after you were born. And what was that, and did it affect your family?
It affected our family like most families, and jobs were hard to get in those days. And even as a child, I remember the difficulty of my father in finding a position, to the point where my mother ended up going to work and supporting the family for a time.
You have told me in the past about the last 10 cents in the house. Will you share that story with us, please?
Well, it's a legend in our family that my mother, who was a very determined woman, I might say, and a woman of, I think, great skill. It's a legend in our family that she took the last 10 cents in the house, rode the streetcar to the state capitol building, took a test involving her stenographic skills, passed high, when was offered a job, and continued to work at the Capitol for many years. Since it was the last dime in the house, she walked home from the Capitol building.
Will you share with us your story about your mother's pregnancy when she was carrying you?
Yeah, I was child number 4. My folks had moved up from Ephraim, where my dad taught school, at what was then Snow Academy, I believe. And my mother had a very difficult time carrying me during her pregnancy, and the doctor had advised her on occasion that she would never carry me to term. And on one occasion she went to the physician's office, and he had his instruments out and wanted her to abort the fetus right then. And she stood up. She was only 5'2" or 3", and said she intended to have this child, and left.
Has that part of your life had any effect or any relationship at all when you've considered things like parental notification challenges in court?
It certainly pours forth and is there. I'm obligated to follow the law as it's written and to do the best I can with what I have to work with. But because of that experience by my mother and a later experience when I was very young, I've always regarded life as a gift. I got pneumonia when I was 9 months old, and I got pneumonia again when I was 18 months old. And in those days, there weren't any antibiotics, and it was necessary for me to have an operation, and I still bear today about a 6-inch scar where the doctor removed a portion of my ribs and drained my lung.
And save your life.
To save my life, that's right. And so I've always regarded life as a gift.
Until you were 10, you lived on Salt Lake City's near west side.
I did.
And attended school there. Will you tell us a little bit about that?
Yeah, I was born at home at 839 Jefferson Street, which is a half block west of West Temple. And my early schooling was at the Jefferson School on West Temple and about 13th South, thereabouts. Big old gray building. And I went through grades 1 to 4.
What kind of neighborhood, socioeconomically, was the near west side?
Now, it was a blue-collar neighborhood. We had railroad workers. We had those who didn't work at all. We had those who peddled vegetables. We had some who were tavern keepers. Nice people, generally, struggling like the rest of us.
Did you learn to play the bugle in
Well,
Jefferson School?
I learned to play the bugle when I was in the 3rd grade. Miss Marshall was the bugler. She was a wonderful woman. I remember my teachers, Miss Allen in 1st grade, and Miss Forrester in the 2nd grade, who taught me to read, really. She went on to become principal of Lafayette, and then Miss Marshall, who was a fine musician in her own right and a wonderful personality. So she taught me to play the bugle.
Let me show you a photograph of you when you were 10 years old. And I understand that there was a transition in your life when you were 10 years old.
This photograph was taken at Bill Shippler's. Shippler's was a photographer downtown here. When I was 10, my mother had saved some money. My dad had gone to work, finally teaching. He was teaching at Lincoln Junior High. And my mother and my older sister found a house up on 12th East, just off First South, that was in an estate. And Mom had a down payment saved, and we purchased that house and went from a house that pretended to have enough bedrooms for 5 kids to a house that had enough bedrooms for 5 kids in an area that was just below the university and close to schools.
Even though it's not geographically that far from where you grew up or where you were born, I understand that then and maybe even now, socioeconomically, it was a change.
It was a change and almost a cultural change. I went from Jefferson School, which was a wonderful school, to Wasatch Elementary School. Wasatch was on South Temple. It was fed by the Federal Heights and the Avenues area and some of the area in which I lived.
And these are professional neighborhoods?
These are essentially professional neighborhoods, and it was an interesting and challenging change for me.
Tell us about your first day at Wasatch Elementary.
Oh, boy. Well, I had a new pair of bib overalls and went to my first day of school, which was then in the 5th grade. And I was the only kid in school so garbed in bib overalls.
So this was a faux pas.
Well, it was a challenge. I went home at noon and put on some pants and went back.
Were your parents Democrats?
My folks were Democrats, and everybody in Utah almost was a Democrat in 1932.
What happened in 1932? Tell us that.
Well, you may recall that Elbert D. Thomas beat Senator Reed Smoot, and Franklin Delano Roosevelt became President of the United States.
And this was really in the depths of the Depression.
It's the beginning, really. It's tough times. And my mother was a Democratic committeewoman, a precinct person in our neighborhood on Jefferson. My first political activity that I have any memory of is she had a whole series of signs with Franklin D. Roosevelt pictured, maybe 14 by 30, something like that. And when I was about 5 years old, I recall taking those signs around the neighborhood and asking the folks in the neighborhood to put a FDR sign in their window. I was convinced then.
At Wasatch Elementary, I understand that you were on the student newspaper.
Yeah, I edited the student newspaper, believe it or not, called the Blue and Gold. I remember the name. And we would put it out on a mimeograph. As a matter of fact, some interesting people involved in that production, actually. And one of them, believe it or not, was Doug Snow, who became a famous artist. He was our cartoonist.
So his career as an artist began.
Yeah, I've been thinking, I haven't seen Doug for a long, long, long time. I've been thinking of sending him a copy of his cartoon. I still have copies of the newspaper.
And then after Wasatch Elementary, what did you do?
Yeah, I went to Bryant, and then I went to East High School, and got out of East High School in '44. I just turned 17 and was able to go to the university for a year. And then, since World War II was still on, I joined the service. I joined the Navy at 17 and went in the Navy primarily to schooling at Great Lakes, and thereafter.
After you completed your boot camp, I understand that at some point you shipped out on a freighter to the Pacific.
Yeah, I'd gone to California, and after being in California, Del Monte, and the war was gone, is basically gone. The war had ended, both. And I was assigned duty on a freighter, AKA 44, if I remember right. And our cargo was beer. I mean, we had a cargo full of beer. And our destination at that time, the Marshall Islands. We went to Bikini and Weetalk, Kwajalein, and we provided beer. Well, of course, later on, Bikini was the site of atomic energy, atomic bomb experiments, as was, and Weetalk and Kwajalein as well. The Marshall Islands generally were used by the United States as an area of experimentation in atomic energy.
But let's return to, as I understand it, you got out of the Navy in about 47, is that right?
Got out actually in 46. I was only in the Navy for about 15 months and got out in time to start my sophomore year at the university.
What was the GI Bill, and how did that affect people like you?
The GI Bill was one of the wonderful pieces of legislation passed by the Congress of the United States. One of the leaders in that, believe it or not, was Elbert Thomas from Utah. but it provided educational opportunity for those who had seen service in the war, and provided tuition, books plus a stipend. And I, being a frugal person that I was, I used to go on the GI Bill for a quarter, save the money, use that to pay the next quarter. I'd go off the GI Bill for a quarter, and I would do it spasmodically so to extend the opportunity for education. Of course, I lived at home, and I had easy access to the university. I could walk to campus and enjoyed easy access. And then, of course, I worked in the summertime as well, either in construction or I became very adept at selling shoes.
When you mentioned that when you left after your freshman year, there were only about 2,000 students on campus. Did that change as a result of the end of the war and the GI Bill?
When I graduated undergraduate work in '49, the graduating class was about 2,000.
So student population exploded.
Had exploded with the GI Bill and the returning servicemen and University Village and that type.
My understanding is that your leadership role in government almost began after you got back to the university after the war.
And while I had been a freshman, I had noticed that the debate function was on the short end of student funds. And so many of my colleagues in the activities of debate and many independents on campus, returned veterans, decided that the Greeks had dominated the world up there from the beginning, and so we organized an independent movement and elected a broad slate of independent candidates. And again, frugal as I am, I wanted to be on the apportionment board. The apportionment board handled student funds. And I was interested in making sure that debate got their fair share of student funds, which they did.
I understand that the number of debaters increased because of that.
The number increased. We often would take a bus full of kids around the country at the various tournaments, in contrast to sending one or two.
How did you get interested in debate, and why was that so important?
It was important. My brother was an outstanding debater up there, a whiz, as was my sister, my older sister, Julia. And so it had been kind of a tradition in the family. I admired what they had done and wanted to try my hand at it.
Well, I know that debate is important for a variety of reasons, and so let me hand you a photograph, I think, which shows you and some of your debate partners.
Oh, yes, yes. This is a wonderful picture of some of the folks that I participated in with the university debate.
You're wearing a letter sweater. Was that from debate?
Primarily from debate, but I got that gem for a number of activities, but primarily debate. I was active in a number of student functions.
Probably, from my perspective, looking at your debate experience, perhaps the most important part of your debate experience is that's how you met your wife.
My wife, Peggy Watkins, who grew up in New York. She came out here to go to school. My debate partner, Martin Cook, who lives in Southern Cal and is a lawyer. Marty was debating Peggy. And I asked Marty's permission if I could take her out. And he said, why, sure. So I began dating Peggy.
I've got here a newspaper photograph of a handsome young man and a beautiful young woman. And who were they?
Good heavens. Wow.
So who are they?
Well, Peggy was in charge of the junior prom that year. I was her date, as a matter of fact, and believe it or not, this picture is a kind of an interesting picture, because she had been up all night and I was ill. But at any rate.
Who was G. Homer Durham, and how was he important to you at this time in your life?
Well, Homer, of course, was the head of the political science department, and my major was political science. And Homer was a fine teacher and a mentor, and was interested in me and was interested in my family. He wanted me to go on and become a political science professor somewhere. And so we had a family connection, but also a professor-student relationship.
I understand that you were intrigued with the idea of going on for a PhD in political science and teaching at the university level. And why did that not happen?
Well, my mother had progressed from a clerical person at the Capitol building to the point where her skills being recognized, she became the court reporter for the State Tax Commission and had contact with lots of lawyers. And my brother had gone on from the university, having graduated here, had gone on and had gone to Georgetown. And after being interrupted by the war, finished at Georgetown and became a lawyer. And both of them pointed out to me that I would have more flexibility if I were a lawyer. And if I wanted to teach, I could still teach.
And so when did you start the University of Utah College of Law?
Yeah, I started there right after graduation in 1949 and graduated there in 1952 and was exposed to a wonderful array of newly minted professors, really, who during that transition period from the deanship of Leary to the subsequent deanships provided excellent instruction for all of us.
You're wearing a very distinctive lapel pin, and will you tell us what that is?
Oh, that's the lapel pin for the University of Utah Law School.
So you even today take great pride in your connection with law school.
I do. It's a great institution.
Let's focus on one of your professors in particular, a man who taught property law. Will you tell us about him?
Well, that was, of course, Willis Ritter. I took classes from Willis, took property from him, other courses as well. I was a student in many of his classes. And he, of course, subsequently became the successor to Tillman Johnson.
As a federal judge in this court.
As a federal judge in this court. And as a matter of fact, when Willis ended his term of service and passed on, I succeeded to that position.
You filled the vacancy created by his death.
I did.
What was Willis Ritter's reputation among students when you were a student there?
Well, he was a demanding professor. He was a tough professor. He was a well-organized professor. He taught well. He primarily used the Socratic method, but he was obviously well-informed as to the subject. He was, on occasion, irascible. He was kind of a personification, on occasion, of the paper chase. But an interesting, demanding sort of man.
Let me ask you about another professor that you had in law school, but who was a visiting professor that I think that you greatly admired.
Yes. That would be Kenneth Culp Davis. Kenneth Culp Davis taught a summer session, taught administrative law, taught constitutional law, and I took both of those classes. In fact, he lived in one of the sorority houses during that summer, and he was in the process of completing what became an enormous administrative law encyclopedia, virtually. But he was had taught at Harvard, at Texas, at Chicago, and he was an amazing sort of guy, and I thoroughly enjoyed those two classes. And he apparently enjoyed me because I did well in both classes.
You graduated from the law school, you took and passed the bar exam, and then another extremely momentous thing happened in your life.
Well, I got married. I got married, and we could afford to get married because Peggy, after she graduated, and she graduated in 1951, I believe, returned to New York and went to work and saved money. And she and I would correspond almost every day and or call. And she came back in '52, and we got married in September of 1952.
And I understand that you lived then on the near west side of Salt Lake City again?
We did, but we bought a little house down in the central west side in Glendale and lived there.
Because this is important to what happens in your political career, would you briefly describe what kind of neighborhood that was and
It was a small...
who your neighbors were?
Oh, a great neighborhood, actually. It was these were tract homes. These were small, maybe 900 square feet, maybe 1,000 square feet. Some brick, some shake shingles. A young neighborhood with young people.
A lot of veterans?
Lots of veterans, lots of people just starting out. And we were there until 1959 and moved over to Rose Park.
Which is also on the near west side.
Oh, yes, oh, yes.
And that's also sort of a working class neighborhood.
It is and was a little different and a little larger places. Alan Brockbank had developed that over there, and Alan later became a friend of mine. And, but we lived there until 1965.
Tell us about the beginning of your legal career and what you did.
Well, there weren't any jobs. I got out in '52, and I hung out my shingle. I think the largest firm in town had 10 members. That was the Van Cott firm at that point. And so I scratched. And I had a general practice, officed east on 4th South with Irving H. Bailey. And then in '54, well, briefly, I was with the Attorney General. I was up with Clint Vernon, and Clint got whipped in the election. And when, in those days, they cleared out the office, not just the Attorney General.
All of the assistants.
Yeah, we all left. But a great group up there. Alan Sorensen, who became a district judge down in Provo. Lambert Gibson, an able guy. among others, Dick Bond, who went up to the Supreme Court eventually. A good group, a good group. And then in '54, I had an opportunity of going over with Ted Moss in the county attorney's office for a half a day. That was the practice in those days. You practiced in your own office for half a day, and you did public service work for half a day. So over there for 4 years, I prosecuted or prosecuted misdemeanors and prepared and prosecuted bind-overs. Prepared bind-over reports for the district attorney, who was then, believe it or not, Alden Anderson.
Oh, really?
Oh, yes, not Alden would on occasion have me help him try cases. But a lot of what I did in those days was primarily doing bind-overs before the city judges and preparing bind-over reports, and on occasion trying cases if invited to do so.
I also understand that you had some administrative and managerial responsibilities.
Yeah, I did. And we had a good group. But after I'd been there a little while, Ted asked me if I would be office manager as well as carrying on the other responsibilities, which I did. We had an unusual group there, a wonderful group who were
Leaders in the bar, really.
They were nice people. I liked them all.
Let's transition to a different subject. And sometime about that time, you began your political career in the Utah Legislature. And will you tell us about that?
Oh, yeah. In 1959, 59, Nellie Jack, who was a senator from Senatorial District number 5, which was essentially Salt Lake's West Side, went on to higher and better things. If I remember right, she ran for county recorder or something like that. There was a vacancy, and the Democratic Party gave my name, among others, to Governor Clyde, George Dewey Clyde.
Did G. Homer Durham have something to do with that?
Homer Durham called up the governor. Frankly, unbeknownst to me, believe it or not. And at the age of I was 29, maybe 30. I was appointed a member of the Utah State Senate to represent that senatorial district. And thereafter ran again in 1960, and won by a fair margin, like 3-1. Take pride in that because I've lost other things.
Now,
and then I again ran in '64 during the Lyndon Johnson
landslide,
and in '63 I, at a young age, became the minority leader, and in '65 I became president of the Senate.
Because the election in '64 put a majority of Democrats into the state Senate.
Oh yes, and a majority in the House as well. Kay Allen was Speaker of the House.
And who was elected governor of Utah in 1964?
Well, Calvin Rampton. That was when the Lyndon Johnson landslide and the Rampton landslide provided a basis for moving forward, it seemed to me. But I enjoyed that particular phase of my life.
Let me show you a couple of things from that phase of your life, and why don't you share some thoughts about these with us?
Well, this is kind of an interesting piece. This is the cover of the Utah Education Association magazine, the Utah Educational Review. And before that session started, and in those days we met every 2 years and we met for 60 days, the teachers had felt as if they had been shorted, which they had been, and were getting militant to the point where they were even meeting in rallies at the state fairgrounds. And one of the challenges of that particular session was to make sure that the primary and secondary education was adequately funded. And we ended up in being able to provide enough funding for the teachers that year to quiet things down, provide some increases. And that particular feature in that particular magazine resulted from, I believe, the gratitude of the educational profession for a sincere effort at that time to provide adequate funding.
So another sort of theme in your life is the importance of public education and how much you value it and how much you've supported it.
And I always felt that investment, literally investment in the educational plant and in the educational personnel, had such long-range benefits to the whole of society.
To our democracy.
Oh, absolutely essential, absolutely essential. And I'm talking public education and the need to adequately fund public education. We fritter away a lot of our treasure on things where we ought to be investing it in people.
Let's again focus on your career or your service in the state Senate and focus on 1965 in particular. And in Utah there is an important piece of legislation called the Little Hoover Commission. And tell us about that, and tell us what this book is too.
In 1963, I had introduced a piece of legislation relating to the reorganization of the executive branch of government that really didn't get anywhere. We had a legislative council, and there were those who felt like we were imposing on them in some fashion. But when I ran again in 1964 as part of my announcement in my senatorial district, I indicated that I was going to introduce again an effort to reorganize the executive branch of government, similar to the Hoover Commission that had been on a national level. And that had appeared in my public announcement, and as it shook down, I ended up at an early age president of the Senate. And I determined in my own mind to put my name on only one piece of legislation during the time that I sat in the chair, let's put it that way. And so I wrote and sponsored what became the bill which enabled the Little Hoover Commission to be organized, formally the Commission on the Reorganization of the Executive Branch of Government. And it was, Senate Bill number 20 by Mr. B.S. Jenkins. And I got down on the floor, and I had the privilege of the floor in both houses. And that's the only bill that I ever got down on the floor during my tenure as president to speak for. And it passed in both houses almost unanimously. And we organized it fast because we had to move fast. I put a time limit on it. And we hired some expert help in the management field as well and proceeded to move ahead. Cal Rampton named Joe Rosenblatt as the chairman. I served as vice chairman.
Mr. Rosenblatt was a very prominent
Oh,
industrialist.
prominent industrialist and a citizen of amazing capacity. And we proceeded to take 209, if I remember right, executive branch agencies that at that time reported directly to the governor. We proceeded to group those and change those, massage those, and redraw the line.
Into departments, basically.
Into the departments that you now have. And made other suggestions
And then
as well.
created a cabinet level basis for the governor.
Yes. So that the governor could deal with a fewer number of people and at the same time do it in a more efficient fashion. That's one piece of legislation that I lay claim to, and I'm very proud of it.
I understand that Governor Rampton claimed that as the most important thing that he accomplished in his 12 years as a governor.
I take great pride in that, not only in creating it, but also in serving with Joe Rosenblatt. And Joe was really nice to me, and I'm embarrassed to read that.
I think you ought to.
Well, why don't you read it? I read it, I might tear up.
This is April 15, 1966. Dear Bruce, without your constant help and understanding, your patience and wisdom, the job could not have been finished. The most satisfying part of the whole experience has been the privilege of working with you. That's a wonderful honor from a wonderful man. I understand this was such an important piece of legislation that it captured lots of publicity at the time. Is that correct?
It did. It did.
And I understand that one of the people who read those newspaper reports and paid attention to this was someone that you had had as a law professor when you were at law school. And
that was Willis Ritter.
And he contacted you.
He did. He asked me to come down and talk to him.
And what happened?
Well, he had a vacancy in the bankruptcy court, and he wanted me to fill it. And I thought about it and talked to Peggy about it and thought, well, why not? So I resigned as president of the Senate and as a member of the Senate, and I closed up my law office where I had been officing for years with Georgia McMillan up in the Kearns building, and came down and was appointed what was then called referee in bankruptcy, and subsequently became bankruptcy judge.
And this was in 1965?
1965.
And now we're in 2006 having this conversation, so you've been in this courthouse for 41 years.
I'm almost as old as the building. Not quite. Not quite. I think I'm the oldest fixture in the building.
Tell us, well, let's skip over your service as the bankruptcy referee. And then at some point you became a bankruptcy judge, right?
Yes.
And tell us what happened in 1978.
Judge Ritter had become ill, and he died in March of 1978.
Which created a vacancy on this court.
Created a vacancy. At that point in time, you had Willis Ritter, who had been grandfathered in as chief judge, and you had Alden Anderson, who had succeeded Sherm Christensen when Sherm took senior status. It was a two-judge court at that point, and there was a vacancy. And Willis had been there for 29 years, and in 1978, there had been a change in the White House. Jimmy Carter was president. All had requested that for circuit appointments, that there be merit commissions appointed in the various circuits to provide him with suggested names.
And these were groups of citizens and lawyers?
And lawyers, others. And so the congressional delegation in this instance, because it was a split delegation, determined to have a broadly based merit selection committee. 11 members, if I remember correctly, headed up by then Dean Rexley of the BYU Law School, and they opened up the field for applications. And there were lots of applicants, and I was getting a little tired of liquidating and reorganizing
In the bankruptcy
in the
court?
bankruptcy court, so I filed an application. They interviewed 17 out of the number that had filed, and cut it down to 5. And I lucked out, and I was one of the 5 that was recommended to the president. That go around, and this was the first time that this manner of selection had ever been used in Utah. Previously, it had been as a practical matter, the prerogative of the senior politician, usually the senator of the predominant party. And so they opened it up, and I lucked out, was one of 5, and there were 5 recommended to the president. They first went to justice and then to the president. And those 5 at that time, if I remember right, were Dan Bushnell, a prominent lawyer, Tom Green, my colleague, good friend, one of the debate crowd at the university, by the way. Benoit Christofferson, who was a judge in the Logan area, Jimmy Sawaya here in town. So those 5 were the ones that were sent back, all of whom the committee indicated were capable of and competent in managing the responsibilities of the office. And lightning struck, and it's basically lightning. I did have some people who put in kind words for me. I'd known Gunn McKay, of course, in the legislature, and he was aware of what service we had there. And then Scott Matheson was then governor. He had succeeded to Governor Rampton. And Scott put in a kind word. And as it shook down, the bipartisan commission, and it was, those kind words, both of the senators, Garn and Hatch, signed off on the blue slips. Nobody knows about the blue slips, but if you don't get a blue slip signed off on, you don't get the nod ordinarily. They were good and signed off on that, and it was interesting. My son Michael, who practices law here in town now for the power company, had been on a mission in Japan. And Peggy and I had saved some money, and we took the other 3 children with us to go pick up Mike. And And the day after we returned home from picking him up, late August of 1978, I had a call from Justice that I was going to be nominated and I needed to come back and be interviewed. We fixed up some time. They interviewed me the morning of my hearing. In the interim, we had responded to all kinds of written inquiries, including those from the Senate committee. And the FBI had been out looking at everybody. They even talked to my grade school compatriots. That time, I owned a few rental properties. They talked to my tenants. I had people calling me, "What's the FBI worried about you, Bruce?" So they covered the groundwork, let me tell you. They covered the groundwork. And I was interviewed in the morning at Justice, and I went before the committee, if I remember right, that afternoon. Pratt Kessler showed up to the hearing. I'd used Pat as a reference in my application. Among others. And Ted Moss, though he had been bested by Hatch in the election, was kind enough to introduce me to the committee, which he did, for which I'm grateful. And Senator Hatch was on the committee, and one out of North or South Dakota, I've forgotten. Anyway, the hearing ran about 10 minutes, and that was it. And we went out, and Ted had invited Peggy and me and Mike to go to lunch with him at the Senate dining room, as we were in that neighborhood, Mondale.
And he was the senator from Minnesota?
Well, he was then Jimmy Carter's
Vice president?
Yeah.
That's right.
And Ted said, "Hey, Fritz, come on over here. I want you to meet the newest federal judge." And Mondale came over and was gracious, nice, and kind. And I'll always remember him saying, he said, "Oh, to be a federal judge." He said, "You don't even have to talk to God."
What I'd like to do is talk very briefly about your career, your total career as a federal judge, but then focus on one case for which you are internationally known. And how many cases have you decided, either by trial or by some kind of disposition, since you've been on the bench? Hundreds or thousands?
Hundreds. If you want to include bankruptcy, thousands and thousands and thousands. But as a district judge, hundreds, if not thousands. Some amazing cases.
Now, sitting next to you on your left, on the couch, is a pile of 5 bound volumes of books with red spines. And will you tell us what those are?
These, well, they're not everything, but those are published opinions. And the West Publishing Company was nice enough as a service.
So a small fraction of the decisions that you have made while you've been a federal court judge have been published, and then these published decisions have been bound.
Have been gathered together and bound, and I'm sure there'll be 2 or 3 more volumes that haven't yet been bound, but yeah, they're there.
You have a reputation of being a very scholarly, very careful thoughtful writer, as a judicial craftsman. And what I'd like to do now would be to shift our attention to one case in particular. And let me hand you this, which is like a ream of paper, literally.
Yeah.
What is that?
Well, that's the opinion we published in the case called Irene Allen and others versus the United States of America. It was a case that I was randomly assigned after I had come on, and which involved an action brought by roughly 1,200 plus plaintiffs against the United States of America, claiming that they had suffered damage as the result of the fallout from low-level radiation from the atomic testing conducted in the deserts of Nevada at Yucca Flats. The folks nowadays called downwinders, but a significant case, and one that we tried for 13 weeks. Took testimony, a very wonderfully tried case, in my opinion, by the attorneys involved, including Stuart Udall, who went on. And we structured it in such a way that we took representative plaintiffs. This wasn't a class action. This was an action brought by all these folks. And we structured it in such a way that we could take representative causes. We called them bellwethers.
And that
to
relates...
use those as a device for structuring the trial and structuring the evidence, and hopefully end up with a result that would be used as a basis for dealing with those who may have suffered injury as a result of atomic
And the injuries
fallout.
often were various kinds of cancers.
They were cancers and leukemias of various kinds, some more subtle than others. And that's one of the great experiences, one of the great educational experiences of my life, because of the quality of the witnesses that were presented by the parties plaintiff as well as the United States. After we had heard this for 13 weeks, it took more than a year, 16 months if I remember right, to produce this. And
you issued what are called findings and conclusions, and what are they, and what did you have to struggle with as you got this huge decision out?
One of the significant questions where you're dealing with injury to persons has to do with the nature of the injury that they've suffered. And one of the burdens that a plaintiff has in demonstrating that he's entitled to compensation is that he's got to show that it's the fault of the person that he's suing. And part of that fault has to do with showing causation, a connection between the event and the injury.
So between the nuclear explosion and the cancer, for example.
And the cancer. And this is a whale of an interesting area because often the latency period in the developing of cancer is the result of exposure to atomic energy, to low-level radiation. The latency period sometimes runs decades, 25, 30 years. to manifest itself, and the kind of connection that you need to show between the event and the consequence is a very, very demanding burden.
So this is not at all like a intersection collision case where a car runs into the back of another car who stopped at a stoplight.
No, not at all. It's in a highly sophisticated area, and there were some very impressive witnesses, let's put it that way. A man named Carl Morgan, who had been with the atomic program from the beginning and went on to oversee Oak Ridge, was a very impressive man. And
I want to ask you a little bit more detail about this, and to set that up, I'd like you to read something from a wonderful Utah writer, Terry Tempest Williams, and I know that you know her work, and this is from her book that many regard as her, epic, called Refuge, An Unnatural History of Family and Place. And this passage is from pages 282 and 83, and would you share that with everybody?
she says, a little over a year after Mother's death from breast cancer, Dad and I were having dinner together. Over dessert, I shared a recurring dream of mine. I told my father that for years, as long as I could remember, I saw this flash of light in the night in the desert. You did see it, he said. Saw what? The bomb, the cloud. We were driving home from Riverside, California. You were sitting on your mother's lap. She was pregnant. In fact, I remember the day, September 7, 1957. We had just gotten out of the service. We were driving north past Las Vegas. It was an hour or so before dawn when the explosion went off. We not only heard it, but felt it. Suddenly, rising from the desert floor, we saw it clearly. This golden stemmed cloud, the mushroom. The sky seemed to vibrate with an eerie pink glow. Within a few minutes, a light ash was raining on the car.
As I understand, this is not too different from some of the experiences that some of your plaintiffs had in the Allen case.
No question about it. It expresses it as it was expressed by many on my witness stand.
Let me also hand to you, I believe it's the first paragraph out of your opinion in the Allen case, and ask you to share that with us.
Well, I had been thinking for a long time on how to introduce this subject because we were concerned with what people knew at the time that these experiments were being carried on. And so we were interested in the nature of matter and the nature of knowledge about matter. And so, sounds familiar. The beginning language is, in a sense, this case began in the mind of a thoughtful resident of Greece named Democritus some 2,500 years ago, in response to a question put 2 centuries earlier by a compatriot, Thales, concerning the fundamental nature of matter. Democritus suggested the idea of atoms. This case is concerned with atoms, with government, with people, with legal relationships, and with social values.
So after you spent 13 weeks trying this case and nearly a year producing your findings and conclusions, what happened to the Allen case?
Oh, the Allen case went up on appeal. The Court of Appeals reversed based upon what's called the discretionary exception in what's called the Tort Claims Act of the United States. They felt, in their language, that this particular consequence claimed by those who had been injured came within discretionary activity on the part of the United States. It was a decision for which they could not be held responsible. And I thought that their decision was the most narrow effort to deal with discretionary function. It provided an almost blank check for the United States. And I always thought that the United States Congress had determined that no longer like the English king, that the king in fact could do wrong, and that the king, when it did wrong, ought to be responsible. But at any rate, they reversed it. They didn't touch any of the factual findings. They simply said that it came within the discretionary function, and it seemed to me, quite frankly, how can anybody say that one may deliberately decide in the execution of discretion that you can hurt people or kill people?
But what was,
So it bothered me.
but what was left untouched were these hundreds of pages of analysis of the relationship between these nuclear explosions in Nevada.
That's right.
And cancers and leukemias that happened years later to many Utahns and others.
Yes. And one of the interesting things, Jim, is that one of the big fights among the experts in the case was a concept that is endemic to most scientific questions where people get hurt. Namely, the question of threshold. That is to say, you've got to be exposed at a particular level, or the concept of linear. The experts that we listen to point out that exposure to low-level radiation produces a consequence. It produces damage. The threshold people say, well, you've got to be damaged at a particular level to make it meaningful at all. But in the area of public safety, if you're dealing with public policy, it seems to me that you have to err on the side of safety. And so you can accept the linear concept that any exposure may cause damage. The extent of the damage is a different question. The valuation of the damage is a different question. But as far as causation is concerned, the exposure at all may cause damage, a mutation to a cell which can generate into a cancer or a leukemia of some kind. The fascinating thing to me is that the threshold levels that were used in my case, that case, were at a particular level to begin with. And as people looked at it subsequently and subsequently, the threshold levels have gone down and down and down, fortifying the concept of the experts that the plaintiffs presented, that any exposure may cause damage. The extent of the damage is an entirely different question. But we were very selective in those that we used as prototypes or as bellwethers. And we held for only a portion of those and held against many that couldn't establish the kind of causal connection that you needed. And I always felt that the record, the 13 weeks of testimony, was the footing on which the legislature, the Congress, finally recognizing that the king, in fact, can do wrong. And when he does, people ought to be compensated. I always felt that was the initial footing for the Congress to find its conscience and compensate people who had been hurt. And I noted in the newspaper the other day, even now, that compensation now exceeds in excess of $1 billion, a far cry from the modest amounts that we had determined when we listened to people talking about holding kids in their arms and watching them bleed from the eyes and the ears.
Let's focus on one, well, as I understand it, your Allen opinion and the circuit's reversal of it was not only national news but international news. And
Well,
let's focus on one person who responded to you about this. And then there's some other stories I want to ask you about. But
well, one interesting thing, Jim, is the day we filed the opinion, and let me say in passing, in work that we do in court, it isn't just the judge. I have great assistance from those who helped me over the years, who are themselves contributors to the public weal, let's put it that way. My law clerks over the years have been of great assistance to me. When we filed this opinion, the very day I filed this with the clerk, I got on an airplane and went to Africa. I had been asked to go over and talk to some lawyers and judges and officials over in Nigeria and in Liberia. And so I got on an airplane and flew to France and then down over the Sahara down into Lagos, Nigeria. But believe it or not, this little opinion, big opinion, hit the international press, and in the local papers in Nigeria, there were articles about this case of mine. And when they tied in with the local paper with me in my speaking, I was kind of a folk hero, because they had difficulty understanding why a judge, or how a judge, would have either the courage or the temerity to call into question what had been done by the government. In Liberia, well, in Nigeria as well, the military presence, the guns, you're escorted to see an attorney general, and the elevator operator has an Uzi machine gun, this type of thing. Anyway, I survived. I came home. And let me tell you, when I came home, we put down, after those experiences where people are regarded as things, and where the rule of law is a charade, even though people are well-intentioned. When we set the wheels down in the United States, I clicked.
Judge, you mentioned that you returned from Africa, and I understand that the Tenth Circuit's reversal of the Allen opinion went up to the Supreme Court on a petition for Ritter certiorari, and that was denied.
Yes.
And you had earlier mentioned that when you were a law student, you had a visiting professor that you just greatly admired and whom you did quite well in the 2 summer courses that you took. And remind us again who that was.
Well, that was Kenneth Culp Davis, who became well known for his encyclopedic examination of the administrative process. His administrative law treatise is a classic, multi-volumes.
On April 20th, 1988, he wrote you a letter, and if you would, will you share that with us, please?
He says, "Dear Judge Jenkins, the Supreme Court has denied certiorari in the Allen case, and that means that your position is rejected." He says, "Weighing my words carefully, I should like to say that your opinion is one of the greatest judicial opinions I have read in more than half a century of reading judicial opinions. My reaction to your opinion is not a quick one, but a carefully studied one. In the long run, your view should and will prevail, but when will the long run begin on this subject? The Varig decision is debatable on its facts, but the long jump is from Varig to a reversal of your decision." And then he said, "For a supplement to my administrative law treatise, I am preparing a full commentary on the Allen decision. My analysis is heavily dependent on yours. I won't send you a copy of my commentary unless you ask for it, but I shall certainly send it if you do ask for it. Of course, I would especially appreciate your reaction to what I am writing about the Allen case. And sincerely yours, Kenneth Culp Davis."
And he was right, because in the long run, the Congress passed legislation which gave compensation to these downwinders. And I think many people believe that that would never have happened but for your trial and your Allen decision. As a part of this, and maybe even before this, but you have become very interested in how we know things and how we prove things. And tell us a little bit about that, because you've written and spoken widely on this.
Yes. Well, how do you know what you know?
Well, let me ask you, one of your many, many articles is captioned humorously, "Is that a fact?"
Is that a fact? Yes.
And would you share that paragraph from that article with us?
Sure. And people have interesting difficulty, let's put it that way, with the levels of abstraction and speech, and as to what the underlying basic bedrock facts really are. And part of our problem in the courtroom is to get beyond the words to what happened, but how you prove things. When I use this in dealing primarily with students, actually, and I say, "Let me ask you a simple question. When were you born?" And then let me ask, "How do you know?" Well, how do you know what you know? Indeed, how does anyone know? This is a particularly pertinent question, not just in the examination of the garden variety witness who relates what he saw or heard or felt or tasted or recorded with any of his sensory apparatus, but in determining whether the so-called expert is worth listening to. or whether his opinions can be helpful in resolving a disputed question of fact. In making inquiry of an expert, how do you know? Remains a very fundamental question. And it's one that ought to be asked. You see, there are experts who have opinions. But there are many experts who have opinions that are not expert opinions. That's what I'm trying to say.
Right.
But one simple illustration that I used to use in dealing with is that of fact. I used to like to take a Granny Smith apple and ask, are there seeds in that apple? Well, you and I can find out if there's seeds in the apple by, of course, slicing it. You can see it. And you can observe it, and others can slice it and see it, observe it. But in the area of expertise, the more interesting questions that the experts involved in, I think, are there apples in those seeds? And that question is an entirely different question because you're dealing with the nature of the seed, the growth possibilities of the seed, the death possibilities of the seed. You're drawing an inference from your experience with seeds. That's an entirely different kind of knowledge. Entirely different kind of knowledge than what you can replicate or what you can see. That becomes an appropriate subject for an expert who's an expert on seeds or apples or apple trees. Or anyway, the distinguishing between what you can verify and what you can infer, two entirely different processes. And of course, in the litigation process, we deal with disputes, disputed facts, disputed law, but you know, so many cases are driven by facts. And there you need to understand the nature and levels of facts and how they can be used and the manner in which you think about facts.
You have thought deeply about this area for a long time, and I know that one book that is very important to you is a book that was published in 1946 called People in Quandaries.
Oh, yeah.
And will you tell us about that and what you've learned from it?
Written by a man named Wendell Johnson. He places the emphasis on the semantics of personal adjustment, but he enjoys in his examples of pointing out the manner in which you can think clearly about a subject, but more importantly, how we stumble in using words that are sufficiently inexact that we don't really communicate, and how often trouble arises from the fact that you use a word in one sense and I use a word in another, and we simply don't connect. And in resolving disputes, if we're in agreement, we're not talking about disputed fact, we're talking about description. But in resolving disputes, we have to distill the questions or the chaos of questions to a point where we can ask, what is the question for decision? And this is particularly true in the area of facts. What happened? What's the history? What went on? People look at that from different points of view, give different versions, assist people in solving personal problems by recognizing that oftentimes, if you can accurately define the problem, you have the answer in embryo. It's perfectly obvious, it's there. And it's that work in ultimately stating the question for decision. Let me give you an example, a very simple example. Church lady, devout. Maybe I'll give you two. She said, my son's a drunk. Well, sister, what happened? They went down to the tavern. Well, what happened? He had a beer. One beer? Yes. Does that make your son a drunk? The level of abstraction is such. The problem is she's concerned that her son had one beer, and from that she drew all kinds of inferences and characterized him as a drunk. That isn't the problem. The only problem is, in her mind, she should be asking the questions, what did he do? Well, he had one beer. Does one beer equal drunk? You see that all the time in the work you do in mediation and trying to ascertain what it is that people are concerned about. What's the real problem? And often the real problem is hidden behind a barrage of language that people stumble up against and dig their heels in and don't resolve anything.
Would it be fair to say that what you've just described about unpacking inferences and trying to get them to the level of actual experience is what you often do when you pre-try a case?
Well, that's what we do.
Will you
the whole effort is to simplify, and the whole effort is to identify those questions that are genuinely in dispute. If they're not disputed, you're talking description. You're not talking conflict. You're talking description. So it's identification. Identify, clarify, order, unify.
This book was written 60 years ago, and I want to ask you whether it relates to today, even though it's 60 years old. But to do that, I want to ask you to read a paragraph from the book.
Johnson says, whatever else we may say of our time, we must, if we do not deceive ourselves, recognize that this is an age of intensive and candid questioning. As we come to appreciate the degree to which an older generation did not know the answers, we come to understand more and more clearly the importance of knowing the questions, the importance of designing techniques of inquiry by means of which a greater wisdom might be distilled from experience.
I'm struck in that regard by this issue of vital speeches, and ask you, I can take the book, ask you if there's anything that you would like to share about that.
Well, that's an interesting piece. If you'll notice that it's a compendium of speeches that have been given by a number of people, and I was interested in George Bush and Dick Cheney and Karl Rove, and there I am with a little speech called The Whole Truth. And I love the juxtaposition of the subject matter, because it seemed to me that the subject of that speech was basically when we swear a witness to tell the truth, the whole truth, and nothing but the truth, tell what he knows. And the witness is somebody who knows something. That we require him to be candid with the court and to the jury. And my general argument is, when we require that of a witness, why ought not we require it in the same degree of those who occupy positions of power and decision-making, why they ought not to be as candid with the American people as we require a witness to be candid with the court and the jury. Anyway, I enjoyed the juxtaposition.
And Johnson was talking about the importance of asking questions.
Yes.
And expecting wise answers based in experience. And
when I first became a bankruptcy judge, I stayed away from public policy questions and political questions, and who tried to do the same thing as a district judge. And I've been frustrated on occasion. And I've often thought that in our great form of government, the three great departments, the legislative, the executive, and the judicial, that one of the functions, one of the real functions of the legislative branch, and I'm an old legislator, as you know, is to ask questions. You and I both know the end product of an effective cross-examination of a witness in court, to test what he knows, getting back to the fundamentals again. And I yearn for a Congress that asks the fundamental questions on matters as important as war and peace. And I wonder where that function has gone to. They delegate it, but the questions need to be asked, and they need to be answered. And in order for people to know something in formulating public policy, they need to ferret out an accurate picture of the world, and not just rely upon what somebody said to somebody who said to somebody. You and I know what we do with hearsay in the courtroom. Well, I am a believer in the Constitution of the United States, and I'm a believer in each branch of government carrying on its function. And one of the great troubles that this country gets into is when the legislative branch delegates too much to the executive, or the executive interferes with the legislative, or they both interfere with the traditional functions of the courts. I'm a believer in the fact that those founding fathers, when they fractured that power, when they fragmented that power and fractured that power, they knew exactly what they were doing, and we see historically what happens when the balance is interfered with.
let me return to one theme which I think is kind of a golden thread in your life, and that is your reverence for public education, your reverence for the role of teachers, and ask you about an article that you wrote 32 years ago in the Utah Bar Journal called Communication in the Courtroom, the Lawyer as an Educator, and ask you to read a paragraph out of your article that you wrote in 1974.
Well, I said the judge is a steward of power. He holds power from the people in trust for the use of people. The function of the courtroom lawyer is to convince the judge to use or to refuse to use such power. The mission of the courtroom lawyer is to have the power of the people personified by the judge stand with his client. The process by which such convincing best takes place is an educational process, and it is in this sense that the lawyer is a teacher and the judge is his pupil.
In the 32 years since you wrote that, do you still ascribe to that sentiment?
I subscribe to that even more so. It's been fortified by the experience that I've had. And I've had great teachers, great lawyers in the courtroom. And the lawyer not only is a teacher of the judge, and one of the nice things of being a judge is the variety that you see. Good heavens, the world drops in, and you go you become educated in everything from the patentability of a hose nozzle to the fallout cases, to securities cases, on and on. But the lawyer not only has to be a teacher of the judge, he has to teach his client, and he has to teach the other lawyer. All of that is it seems to me, is an educational process, and quite often he has to teach the jury. Not only teach, but persuade, but I've always felt from the beginning that the best argument is a good explanation.
In 32 years or longer, because I'm not sure when you first published your first article as a judge, and then you were a bankruptcy judge, but you have been in great demand as a public speaker and as a writer. And sitting next to you on your left on the couch are 6 very thick 3-ring binders. And will you tell us what those are?
Well, that's a compilation of most of the speeches that I've given, not all, but most, some good, some bad, some that I've improved upon. But that's a compilation of occasions when I have talked to various groups about various subjects.
One reason that you have been in demand as a speaker is that you really are quite funny. And
well, some people don't think so.
You wrote an article called "The First Thing We Do," and would you read those few paragraphs from that? That's
well, this was a recital of one of the occurrences in court some years ago. Some years ago, a defendant standing by the side of his court-appointed attorney wanted me to reconsider a pro se motion filed by him, which I had previously denied. The following took place. This is from the transcript. The court, we're going to set a trial date today. Your motion to dismiss I have considered, sir. It looks to me like you have nothing to add to it. The motion will be denied. Let's fix a date. And then the defendant said, Your Honor, I am bound by the laws of God to state to you that you were in violation of your oath, that you were a criminal under the laws of the United States of America. I command in the name of Jesus Christ, the angels speedily take your spirit to the spirit prison and there retain you until the resurrection of the unjust. In the name of Jesus Christ, amen. And I replied, okay. Now let's fix a trial date.
I've had a number of opportunities to sit in your court awaiting my turn on a motion, for example, and there will either be a pro se party or a tax protester, or someone with fairly clear mental problems of some kind, and they are in the process of abusing you, as this transcript illustrates. And you just are marvelously patient with them. I've never seen you lose your temper, ever, with people like that. And you once told me that your father, when he was a teacher at East High School, had a reputation for being able to get along and work with the most difficult students. And is there something there genetically also?
My mother and dad were interesting people. They were both very, in my opinion, talented people and fun-looking. I brought a picture of my mom and my dad with me. Her name was Bessie. Her name was Bessie Iverson. She was one of 12 children of Andrew Iverson and Julia Iverson of Salem, Utah. And my dad was Joseph Jenkins. And my dad was one of 14 children, and he was from Goshen, Utah. And both placed great emphasis on education and the desirability of having a good education.
Do you think that from their example or their teaching that you saw the value of being patient and tolerant and respectful, and with especially people who disagreed with you?
Well, I think that they were both strong personalities. My mother particularly was a strong and determined lady. But they were both tolerant people, and they were questioners. They were interested in life, and they were interested in civic activity, and they were inordinately interested in their children.
Let's turn now from talking about your judicial career and talk about your family. I know that your family is probably even more important to you than your judicial career.
Peggy and I had 4 children. We are always even-handed, so we had 2 girls and 2 boys. We had a girl on each end and 2 boys in the middle. And then we have, they all married. They all went through college. David, the oldest boy, became a PhD in anthropology. Lives in Maine. Judy was a school teacher and then became a full-time mom up in Seattle, the Seattle area, and is now back teaching part-time to find an outlet for the energy that she has. Michael, the second boy, is a lawyer with the power company and has been off and on during his legal career, even when he was going to school. And then Carol was a teacher for some years and has a business of her own. She has, believe it or not, a business that caters to children between infancy and 7 years of age called Kinder Music, and she and her associates have classes that number about 200 now, as far as pupils go. And she reminds me of my dad as far as her ability within a classroom. Just amazing. And we make great effort to have fun with both kids and grandkids, and they with each other. Let's say that we have a panoply of differing views. All of them have views of their own, and none of them hesitates to express of you even when they contradict me, which they enjoy doing. They join their mother in making sure that my humility remains at a level that they can tolerate.
Well, you have some, they can't be called hobbies because they're much more important than that, but avocations, I think, would be fair. And you love books, you collect books, you love to go to bookstores, you love history, you love LDS church history, you're a student of it, you write about it, you've contemplated writing a book or several books about it. And yet you stay on the bench because you love it also. And,
Yes, yes.
And how do you see these avocations with your commitment to the court?
Well, I love what I do, and I always have. Wherever I was, quite frankly, I thoroughly enjoy what I do. I like to feel like I can contribute to assisting people in resolving problems that they've been incapable of resolving for themselves. And that's a challenging work, and that's a fascinating work, and I love to do that. This little book I bought a long time ago when I couldn't afford to buy a book like this. I bought it from Sam Weller. It is the session laws of the first territorial legislature of Utah. And it was printed in 1852. Contains the acts, the resolutions, and the memorials of the first annual and the special session of the Legislative Assembly.
Could I ask you to turn to page 55 and share that portion of it with us?
I used to love to take this up on the bench when I was President of the Senate, and I would often quote from this little book. But page 55 is having to do with the it's called an Act for the Regulation of Attorneys. And I think this is so wonderful. It says, the resolution says that the right of being heard by self or counsel shall not be denied to any person claiming a trial as plaintiff or defendant in any court in this territory. And it shall be the duty of all judges of courts in this territory to grant a hearing as counsel to any person of good moral character chosen by any person or persons to prosecute or defend a case in which he, she, or they are a party. You're just saying that you may be represented by a person of good moral character. Anybody can be a lawyer as long as you're of good moral character. And then the kicker was that I always used to kid my fellow practitioners with this. It says, Section 2, no person or persons employing counsel in any of the courts of this territory shall be compelled by any process of law to pay the counsel so employed for any services rendered as counsel before or after or during the process of trial in the case. Well, you can be represented by anybody of good moral character, but the poor lawyer can't sue to collect his fee.
I'm going to ask you to share one final story, and then I have one concluding question. So the story I'd like you to share is, do you have a gavel, and where is it?
I have a gavel, a huge gavel. I've got it over there on my shelf. It was made for me by Mark Garf, a neighbor. Mark gave me that when I was sworn in. I'd had gavels up at the State House as well. I don't use a gavel. I don't use a gavel. Oh, that's fun.
Let me sum up with the kind of question that is sometimes put to expert witnesses, which is, puts the number of conditions together. And if you hadn't known G. Homer Durham, and if he had not expressed so much interest in you, and if he had not recommended you to be appointed to the state senate, and if you had not become president of the Senate and had an opportunity to pass this piece of legislation that people regard as incredibly important on the Little Hoover Commission, and if that had not inspired the attention of one of your law professors who remembered you from law school and invited you up 41 years ago to serve in this building, what do you think your life would have been like?
That's a wonderful, iffy, hypothetical question. So much that we do in life, I think, is serendipitous, is random. I frankly don't know. I think I probably would have gone on to practice law and done so with less enthusiasm than what I have been fortunate enough to do as the result of lightning striking and forces converging. One of the ifs that perhaps ought to be placed in that list, Jim, if there hadn't been a citizens selection commission that was used for the first time in Utah, in my mind, I would have had little, if any, opportunity to serve.
If it had just been purely politics.
The fact that Carter was elected, the fact that there was a selection commission, the fact that Rexley and Waldover headed that up, the fact that I wrote a darn good application. I've just been lucky, let's put it that way, and I've thoroughly enjoyed what I've done and hope I can continue to do some. But, you know, I've had, I need to say here, I should add right now, I've had wonderful colleagues to work with. I've had wonderful clerks who've been of assistance, who themselves are gifted people. My office staff here is family. My colleagues, I couldn't say nicer things about. They've been wonderful, and those who've departed, Anderson and Christensen, and even Willis, have all been kind to me. And
well, on behalf of the bar, I wanted to thank the 10th Circuit Court of Appeals for having created this oral history project. The time that you and I have shared together today reflects how important this project is, how valuable it is to capture forever, you know, the memories, the achievements, the relationships of, you know, such a wonderful person, wonderful judge.
Well,
I'm greatly honored to be one of your friends.
well, we go back a long way. I remember when you clerked for Willis, and we used to share the bus coming downtown. And your own career has been exemplary, and we are good friends and have been, and I think share a lot of the same kind of motivations and interests and appreciations for the freedoms that we have.
Thank you, Judge, for the honor of
Oh, gosh,
interviewing you
thank
today.
you for being so nice.